This, okay. All right, good afternoon, ladies and gentlemen. My name is Judge Long, and we are going to begin with our state court expedited accusation calendar. These are misdemeanor cases in which individuals were recently arrested and brought to the Fulton County Jail. Once they were booked in, the prosecutor, which is the Solicitor General's Office of Fulton County, has already formally accused these cases. Hence, this would be the defendant's initial appearance before a judicial officer. When I call your case, I will let you know what is your accusation number, what are the charges brought against you, who is going to be your attorney, and what is your next court date, if applicable. I'll also set a bond in your particular cases, and for some of those cases, we will give you a new court date. For the individuals who do make bond, for those individuals who do make bond, you will receive a court date that will be mailed to your current mailing address. So once you make bond, make sure that we have your current mailing address, as well as the address and contact person of your attorney, if you've already retained one. If you are still with us at your next court date, then we will address your cases while you are still at the jail. The next court date would be May 16, 2023 at 9 a.m. Some of those calendars, this may be either a hybrid calendar in which the judge would be in courtroom G33, or it may be a purely Zoom calendar. So please be mindful that if you have a new court date and your counsel or a witness, you will be advisable to get the Zoom link for the next court date. For individuals who have been charged or accused of misdemeanor offenses, please remember that when I address your cases individually, you do have a right to remain silent. Anything that you choose to say during the course of these proceedings, which are not only recorded but live streamed, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, we will appoint counsel to represent you either from the public defender's office or from the conflict defense list. All right, courtroom 2, who do we have, please?
Good afternoon, Judge Love. This is going to be for position 1, Ms. Blackwell. She has a private attorney. I was checking to see if the private attorney was present.
Yeah, Mr. Gudice. I see Mr. Gudice made an appearance. Is he? Looks like he hasn't chimed in yet. So
Okay. We'll hold
who's
off
our
on
next
that
one?
one.
Okay.
Position 7, Pulliam.
This is Gillette Pulliam, middle name Shante, accused of battery, case number 23 CR 002681E. The alleged offense date appears to be March 11th, 2023. Ms. Pulliam, you've been advised of your right to remain silent, and your attorney is Ms. Maureen McLeod. Pre-trial is going to be Ms. Roberts. Good afternoon.
Good afternoon.
Do you have any Go ahead.
Yes. She has 21 cycles, 3 FTAs, 2018, 2016, 2014. Appears to be on probation out of Douglas County for aggravated assault and terroristic threats. That probation is from 2019, December of 2019. The ag assault was 8 years. The terroristic threats was 5 years. She has a 2019 conviction for criminal trespass and battery, a 2019 conviction for driving while license suspended or revoked, 2018 financial transaction card fraud conviction, 2017 forgery, identity fraud, and criminal attempt to commit a felony conviction, 2016 willful obstruction of a law enforcement officer, theft by taking, and forgery.
That's good. Thank you.
Okay, you're welcome.
Ms. Duncan, what's the state's recommendation?
Yes, Your Honor, in this case, it did occur on March 11, 2023 at 10500 Alpharetta Highway in Roswell. The victim in this case is Jamia Carter. That's Jamia, Carter, common spelling. And in this case, we are going to be requesting that the bond be reduced from a $10,000 total surety to a $5,000 total surety, because in this case, the victim, Ms. Carter, was with the defendant at her home on the date previously stated on the calendar, she said that she was going to receive money from the defendant in this case, and the defendant made her some drinks, one of which she saw, the other of which she did not. And at that time, she said that after she got the second drink, she began to black out. She somehow found herself in a car with the defendant and another person somewhere in Roswell. She indicated that while she was riding in the car, the defendant began to strike her in the face and head before putting her out of the car. She said she doesn't know how she got out. She knows that she ended up at a gas station, which is where she called the police. She indicated to officers that she believed that her second drink may have been drugged. Your Honor, we're going to ask for that reduction just for the simple fact that we do understand the risk of reoffense here. She does have a violent conviction for aggravated assault. We do have some concern about the particular danger to this witness in general and the danger to the community that this defendant poses, given her violent history. We have concerns about the flight risk, given her recent FTAs, and the likelihood to respond to the legal process, given that she's currently on probation for violent offenses and continues to reoffend violently. For those reasons, we think and we were not able to make contact with the victim. We ran several searches and were not able to make contact. However, we still would like to sound for her. Given that, again, we would like to request a $5,000 total surety, no further contact with the victim, in this case, Jamia Carter, 2 weeks of anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law. We would like the court to sound for Ms. Carter just in case she is here.
Ms. Jamia Carter? Ms. Jamia Carter? All right, Ms. McLeod?
Yes, Your Honor, good afternoon.
Afternoon.
My client is 31 years old. She tells me that she works as a therapist and that she is also an author. She denies that she attacked Miss Jamia at all. In fact, she tells me that Jamia is essentially a client of hers who has been counseling with her. She said on the occasion in question, she became quite drunk and they were out in the car and she asked to be dropped off by the Hooters. And that was where she was dropped off at. My client denies that she ever struck Jamia at all. And she believes that the alleged victim has some kind of mental health issues, which causes her to make stories up. I would like to point out to the court that even the officer who got the warrant states that a lot of what the alleged victim was saying was inconsistent, and some of it that the officer did not understand. I know that my client does have some history, Your Honor, but I would ask the court to consider giving her a signature bond. These they don't live together or anything like that. They just know each other, and there is no reason why they have to be in touch with each other. And if the court is disinclined to do that, I would ask the court to give my client a lower bond, one that she is more likely to be able to make. Nothing further, Your Honor.
Thank you. Bond is 2,500. It is a surety bond. Next court date's May 16th. No further contact with Jamia Carter. No alcohol, no illegal drugs, no weapons, and no firearms. Thank you.
Thank you, Your Honor. And that concludes my business before the court today. May I be excused?
Oh, okay. Yeah, sure. That was fast. Thank you.
Yes, it was. Thank you, Your Honor.
Okay. Is Mr. Gudice on the Zoom? No? Okay. Next case, please, Principal.
Position 2, Bonnier.
This is State versus Kadua Bonnier, 23 CR 002679G. Ms. Bonnier has been accused of battery domestic violence from an April 30th, 2023 incident. Accusation number is 23 CR 002679G. Ms. Bonnier, you've been advised of your right to remain silent, and your attorney is Ms. Wills. And Ms. Roberts, any priors?
3 priors, 2018 conviction, driving without a valid license. Appears to be on probation out of Fayette County for driving while license suspended or revoked. That is from September of 2022. It was 12 months probation. And then she had a DUI arrest January of this year out of Cobb County, and that appears to be open and nothing further.
Ms. Funk, good afternoon. What's your recommendation?
Good afternoon, Your Honor. She also has a dismissed 2010 battery from Florida, so she is a multi-state offender according to our poll of the GCIC and NCIC. Our concern here, Your Honor, is this individual, the victim in this case, was 14 years of age. We will go with his initials AB. When he encountered his mother, who struck him because he talked back to her. She claims she struck him one time. According to AB, she struck him multiple times and he pushed her away to get him off of her. And that led to them wrestling and him having a swelling and laceration to the right side of his face. We did have an opportunity to speak with Mr. Stephen Bonaire, who is the victim AB's stepfather and the defendant's husband. He claims that Mr. AB is very disrespectful and that the defendant is currently, the victim is currently at the defendant's sister's home, so the aunt's house. He also said that AB has a case in juvenile court, which we were able to confirm, and that he is they're trying to find him another home because they cannot deal with him. He further stated that AB has destroyed property at the apartment complex, which has caused them to be evicted. I would say that there is appearing to be multiple issues going on in this home, but based on the warrant and our concerns regarding AB's treatment, as well as some of the interactions that are happening here, we do believe it is best to keep AB and the defendant apart from one another. Our recommendation is going to be a signature bond only because the defendant does not have a violent history that we were able to ascertain. So we are recommending a $5,000 signature bond through pretrial services, no further contact with AB for the time being, no alcohol, drugs, or weapons, and we are recommending a parenting class as well through pretrial services. I do believe that Mr. Bonaire is here, but again, I would point out that that is not the victim in this case. AB, the juvenile, is in fact the victim. That's all for the state.
Thank you. Ms. Wills, do you have any objection to a 5,000 signature bond? If you want to address contact, are you any issue with that?
Yes, Your Honor, no objection to the signature bond. At this time, my client has indicated that she has been struggling with the child's behavioral issue. That's been a long-standing issue that her and her husband have been facing. I would ask for contact, that they be allowed to have nonviolent or at least verbal contact, given that that is her child. But as it was stated by the state, my client has made arrangements for the child and he is no longer in the home.
I'm going to set the bond at $5,000. It's going to be a signature bond through pretrial services. Ms. Bonaire, you can sign up for your bond. You don't have to pay for that today, but you will be sent notice for your next court date. No further violent contact with the alleged victim, AB. You are to comply with any requirements as set by another agency, such as defects or child services. And you are to also make sure that you do not consume any illegal drugs, no alcohol, and not consume and not possess any weapons or any firearms. If there are any weapons or firearms at home, they must be removed and either sent to the authorities to be purged or to be destroyed. Understood?
Yes.
You may return to the Sonoya Road location. And from this point onwards, it'll just depend on whether defects gets involved or any kind of child support services agency to manage this, the future with you and your son.
Okay.
All right, but don't forget to come back to court. Thank you.
Your Honor, I will point out we did not ask for a stay away, and I understand why Your Honor is doing a no further violent contact. However, can we put in a requirement they not reside together for the time being?
I'm not sure. I think I'm going to let the defects and child support services handle that.
And the problem is, I'm not sure if DFACS is in fact involved in this case at this point, and I don't want to have DFACS be in charge of handling this if they are not currently involved in the case.
This is problematic because you're asking me to keep the victim away from the residence. So that would be a problem. I think, Ms. Pulliam, you will need to make sure that defects gets involved. if he is under the age of 18. Okay?
I understand, Your Honor. Thank you.
And if he comes back and lives with you, you need to get a child support services, because if you get in trouble with this individual, AB, again, and the authorities get involved and they know that you have a case pending against you, you stand in jeopardy of losing your bond and being arrested again. Yes, Ms. Pulliam?
Her last name is
I
Bonnier.
wanted to say something. I have a lot of things in place for him. He's on probation, so he has a probation officer. We're working on trying to he's an IFE, we have counseling. He see 5 therapists a week. We do family counseling. We got family counseling Wednesday. So we've been working on trying to get a lot of stuff in order for him. So I don't really want to be, if we can have supervised visits, because I have with his probation and his court proceeding from throwing hot water on my daughter, he have a case on his own. I have to be involved in these counseling sessions.
Okay.
In a place, in a facility for mental health.
Where's he staying?
As of right now, he's at, since the incident, he's at my sister's house.
And is he going to stay there until your case against you is resolved?
I'm going to make sure he stays there. If not, I have another cousin that's willing to take him if he can't stay there. Her name is Nikki, Tiffany Bush.
All I'm telling you is that I've got a no further violent contact against you. So you cannot have a physical or verbal altercation against AB, or you risk the chance of being rearrested. He can return to the property because I cannot restrict him, but he can be managed by defects or child support services or juvenile court if he's on probation. Do you understand?
Yes,
Okay, but these restrictions that I impose are against you.
I understand.
You can speak to Miss Wills on how to conduct yourself accordingly.
Okay.
All right. It's pretty, no, we're good. It doesn't have to be project. No further violent contact, no alcohol, drugs, and weapons. Yeah. All right.
Position 1, Blackwell.
Right, Mr. Gudiche?
Your Honor, Beth Jeffrey for Ms. Blackwell.
All right. Okay, this is State versus Andrea Blackwell, case number 23 CR 002680Y. This Blackwell has been accused of simple assault domestic violence from a April 29th, 2023 incident. Ms. Blackwell, you've been advised of your right to remain silent, and your attorney is Miss Beth Jeffrey, also with the Gudiche firm. And any priors, Ms. Roberts?
No priors, first arrest.
All right. Ms. Folk, any recommendation?
Yes, Your Honor. We did have a chance to speak with Miss Gina Blackwell, who is the mother of the defendant and is the victim in our case. And she stated that she and the defendant lived together at the incident location with her granddaughter. She stated that she believes the defendant has an alcohol and drug problem, and that she has been to facilities multiple times, approximately 4 times, and has relapsed each time. This is important because in this case, the defendant was under the influence of alcohol, and that was observed by the officers at the scene as well. Miss Blackwell stated that they were in a verbal argument. The defendant picked up a picture frame and advanced towards her as though she were going to throw it. There is statements in the warrant as well that the officers spoke to the defendant, who admitted she picked up the frame when she was angry and she acted like she was going to throw it, but she stopped herself. Miss Blackwell is scared of the defendant returning back to the home. She says she only wants contact with the defendant because of her granddaughter, but does not want the defendant to return back to the residence. And she stated she does want an ADET for the defendant. So to that end, we are recommending a $3,000 signature bond through pretrial services, that the defendant stay away from 1818 Adagio
Drive. in
Yes,
Atlanta?
no further violent contact with Miss Gina Blackwell, and we are asking for no alcohol, drugs, or weapons, 1-day anger awareness. We are requesting an ADET, especially considering both the officer's observations of intoxications in this case, as well as the mother's representations. That's all for the state.
Thank you. Ms. Jeffrey, it looks like the state's agreeing to a signature bond through pretrial. Do you have any comment about the request for an alcohol and drug evaluation and the contact and stay away provisions?
Your Honor, as far as the stay away provisions, obviously if the victim is saying that she wants a stay away provision, then that's something we would have to abide by. As far as the drug and alcohol evaluation goes, at this point, she is presumed innocent, and to put this burden on her just for the matter of getting a bond, I don't think is appropriate. Obviously, she has to abide by all conditions of the bond. We have no opposition to the signature bond, just depending on the level of supervision. She is employed full-time as a vet technician, and I just am concerned about some of the reporting provisions of pretrial. That will be the biggest issue.
And Your Honor, I neglected to mention that Ms. Blackwell is here. She is on the line, and I believe she's unmuted and may wish to speak.
Ms. Gina Blackwell, this is Judge Law. If you'd like to contribute to this hearing, you're free to start your video and your audio, but I'll need to place you under oath. Ms. Gina Blackwell.
Yes, ma'am, I'm here.
Oh, there you are. Okay, I wasn't sure. Okay. Did you want to add anything or shall I proceed?
So my concern is,
May I place you
yes.
under oath? Do you
Yes.
solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
It will.
All right. What are your concerns?
So my concern is the 5-year-old minor. My daughter, Andrea, and her daughter, my granddaughter, live with me. And my concern is that if I ask for a stay away order, then the 5-year-old will go with her.
That would be correct.
Yes, and so that's my dilemma, because I know my daughter is under the influence, and I think that she was willing to, I think she had gotten to the point where she was wanting to get some help, because as a matter of fact, had made an appointment for a detox center the following day after this incident occurred. And so I know she wants to get help. And I don't want to have a complete stay away order, because I'm afraid if my granddaughter goes with her, they have no place to go. She doesn't have a place to live. So that's my dilemma.
Okay. I'm going to go with the state's recommendation of the $3,000 signature bond for pretrial services. Miss Andrea Blackwell, you're to have no further contact with Gina Blackwell until after you have completed your alcohol and drug evaluation and submitted yourself to any treatment. Once it's determined by the not pose any immediate threat to Gina Blackwell, then you may resume contact. You are to stay away from 1818 Adagio Drive in Atlanta, Georgia. You may return one time only with a police officer to retrieve your personal belongings as well as your daughter. Under the law, you have custodial rights over your daughter, and whether Miss Gina Blackwell gets to visit her daughter, that is something that would have to be taken up in Superior Court. Because right now, in the eyes of the law, unless there is a court order seriously questioning the competency of Miss Andrea Blackwell as a parent, she has the exclusive right to determine visitation and joint custody with any other person. So you can return one time only, but you must make sure you go with a police officer, and that visit cannot exceed 2 hours. Yes, under a charge of domestic violence or family violence, the court can order other particular conditions that are not necessarily ordered in a non-family violence case. And that could include a domestic violence intervention program, as well as alcohol and drug evaluation, anger management classes, and so forth. Presently, based on the allegations set forth in the warrant, I am ordering you to undertake an alcohol and drug evaluation with a qualified counselor or provider, healthcare provider, and this must be done within 30 days of being released. All right, and if the treatment is warranted, you must submit yourself to that treatment. You're not to consume any illegal drugs, you're not to consume any alcohol, and you will be subject to random screens by pretrial services. You will report to pretrial once a month per the schedule provided to you. No further contact with Gina Blackwell means staying 200 yards away from her, and you do not communicate with her in person, through a third party, through a cell phone, a telephone, or on social media. Ms. Gina Blackwell, if you want to make sure that Ms. Andrea Blackwell doesn't violate the conditions of the bond, I highly recommend that you do not initiate any communication with her. If you believe that Andrea may be a threat to the minor, you would have to retain counsel and consider intervention through a superior court order.
Thank you. I've already done that.
All right. Okay, that concludes this case. Next, another thing, Ms. Andrea Blackwell, you must update the court with your new address within 30 days of being released, because we will send you notice of your next court date, and you would also need to keep up with your attorney to find out what's required of you. Thank you.
Thank you, Your Honor. That completes my business. May be excused.
Yes, thank you, Ms. Jeffrey. Have a good day.
You as well.
Position 9, Shackelford.
Terry Shackelford is accused of DUI under the influence of alcohol, less safe and improper and erratic lane change from April 30th, 2023. Ms. Shackelford, your case number is 23 CR 002682F. You've been advised of your right to remain silent, and Ms. Roberts, any priors?
No priors, recommended for a UJR to the jail.
All right. Ms. Duncan?
Yes, Your Honor, this incident occurred in the area of 1025 Melody Lane, where officers responded to a single car crash at the intersection of Norcross Street and Melody Lane. When they got there, they encountered the defendant in this case, and there were multiple third-party witnesses there. He got there about 3 minutes after they called 911. He did notate that the mailbox belonging to the house at 1025 had been completely run over and damaged by the defendant's car. When he did make contact with the defendant, she admitted that she had drank 2 beers prior to operating her motor vehicle. He indicated that she was unsteady on her feet and was mumbling, had slurred words while speaking, and that she was not wearing any shoes. He asked her, did she want to participate in field sobriety? She did not answer his questions. She continued to scream and cry and talk about other things to the officers, and continued to do so while also in the car. So the officer likely took that as a refusal. She was taken into custody at that time. We do have some concern about the risk of reoffending, as she did indicate to officers she did drink before driving in this instance, and as we know, DUIs can be dangerous. Under this manner of driving, anyone could have gotten hurt. Instead of a mailbox, it could have been a person. For these reasons, Your Honor, given that it was a mailbox, and we want to make sure that this defendant is getting the help that she needs, we're going to request a $2,000 surety on the DUI and a $500 surety on the improper lane change, no alcohol, drugs, weapons, no further violations of Georgia law in ADET, and no driving unless allowed to by DDS, given that this is a DUI and she did refuse field sobriety. Nothing further from the state.
Ms. Kim?
Yes, Your Honor, we would like to recommend for signature on bond. She is recommended for a UJR. This is her first offense ever. She is 47 years old. She was born and raised here in Georgia. She's married, and she has one daughter who is 22 years old. She has been very successful as a real estate investor ever since she graduated from high school. Your Honor, we would like to request for definitely signature on bond for lane change and DUI. If Your Honor is not inclined to give her a signature on bond, we would like to request for maximum $1,000 good bond. Thank you.
And Ms. Kim, is your office going to continue representing her, or does she need to retain private counsel?
She does need to retain private counsel, Your Honor.
All right, thank you. On the driving under the influence of alcohol, the bond's going to be set at a $2,000 surety bond. On the improper erratic lane change, it's going to be a $1,000 signature bond through pretrial services. This is going to be a split bond. After she bonds out, she needs to report to pretrial once a month. She will be subject to random screens for alcohol and or illegal drugs. There cannot be any consumption of any alcohol or illegal drugs. And her driving ability will be limited to whatever driving privileges that the Department of Driver Services provides. So within 30 days of being arrested for DUI, your license is suspended unless you do the requisite appeal. And if you prevail, the driver services could provide you with limited driving privileges. But this is something that you would have to take up with the Department of Driver Services. Next court date will be May 16th. This is a $3,000 split bond. Next court date's May 16th. If you do make bond, then your new court date will be sent to your mailing address. Thank you.
Thank you, Judge.
Position 10, Simmons.
I'm sorry, position 7, was it?
No, position 10, Simmons.
This is Brianna Simmons. Ms. Simmons has been accused of simple battery from a April 30th, 2023 incident. Accusation number 23 CR 002684B. Ms. Simmons, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kim. Any priors, Ms. Roberts?
I am showing one prior arrest out of Ohio from 2013 for theft, possession of criminal tools, and contributing of a child. And I did not see a disposition for that case.
Thank you. Ms. Duncan?
Your Honor, in addition to that, for that theft and possession of criminal tools from Ohio, I did see a disposition as dismissed. However, I did see an additional arrest out of Ohio in 2022 for telecommunications harassment, and it says that she was arrested on April 19th, 2023 in Ohio, but I did not see a disposition for that one. In this case, Your Honor, the state is going to be requesting a $2,500 surety. This incident did occur at 5501 Glen Ridge Drive. The victim in this case is Shamaya Mitchell. That's SHAMYA Mitchell, MITCHELL. It's indicated when this case was accused, Your Honor, we had limited information, and it was indicated that the defendant did in fact bite this victim, as witnessed by a third party, Carol Wilson. Since then, we do have some concerns about the risk of reoffense and this particular defendant's ties to the community, given her recent arrest in Ohio. We were able to speak to the victim later on this morning, and she indicated to us that she was just good friends with this defendant, and that it was the first time something like this happened. She picked her up from work and they went to a bar. She stated that the defendant was getting drunk and got an attitude, so they were leaving. There's somehow some type of argument started, and that she started to mumble things to her that she did not understand, and started to tell her that she would kick her ass and things like that while they were driving, and began to assault her while she was driving. She stated that she went to the daycare to pick up her 1-year-old daughter, and the defendant was attacking her numerous times while she had her daughter in the car. She asked this defendant to get out of her car several times, and that she would call her an Uber, and she refused to do so. And then she further indicated that while at the sitter's house, she tried to call the police, but the sitter would not let her. So she called her mother, who was on the phone listening, and her mother asked the defendant in this case to stop attacking her daughter and to leave. She indicated to our victim advocate that she almost crashed her vehicle because the defendant was attacking her while they were driving. She grabbed her by a shirt, broke her chain, and at some point bit her during this attack on the victim. We further found out that she sustained a bite mark to her arm that was bleeding, and there were other scratches on her body from this attack. The victim indicated to our, as well as from her digging her fingers into her, which caused a scar. The victim indicated that she was checked out by ambulance on scene and they gave pain medication. She said that she doesn't want any contact with this defendant and to stay away from her home, which is that 5501 Glen Ridge address. It's for these reasons, again, Your Honor, we're going to be requesting a $2,500 surety. No further contact with the victim in this case, whose name has already been stated on the record. Stay away from the incident location, which is the victim's home per her request. 1-day anger awareness, no alcohol, drugs, and weapons. And just in case the victim is here, the state would like the court to sound for her.
Right. Miss Shamaya Mitchell. Shamaya Mitchell. All right, Miss Kim?
Yes, Ms. Simmons is 29 years old. Actually, she was born and raised in Ohio. She came to Georgia to visit her family and friends last Friday. And today, actually, she had a flight ticket to fly out. However, she's at the jail at this point. And we would like to request for a signature on bond, since the last arrest on the record was 2013, which was not violent. And we would like to, she's gainfully employed as a hair stylist, licensed cosmetologist. She has been doing that about 6 years after graduating from high school. And she also has family members and friends here in Georgia. So she will come to the court. And she has no objection to stay away or no further contact with that friend. Thank you.
Bonds can be set at $1,750. It's going to be a surety bond. No further contact with Shamaya Mitchell, to stay away from her residence and wherever she happens to be. You're not to contact her on the phone, through a third party, through a computer device, or even try to reach her through social media. No illegal drugs, no alcohol, and no weapons and firearms. Your next court date will be May 16th. If you do make bond, please keep in mind that you need to make sure that your address is current with us at all times, so that we can send you notice of when to show up in court in the future. Thank you.
Thank you, Judge.
Position, this is the add-on position 1, Mr. Hicks.
This is State versus Javier Hicks, case number 23 CR 002-688C. Mr. Hicks has been accused of driving hit and run, failure of the driver to stop at or return to the scene of the accident. The warrant seems to indicate that basically information was exchanged with the alleged victim, but apparently the information turned out to be not quite accurate. So this is from April 19th, 2023 incident. And Mr. Hicks, you've been advised of your right to remain silent, and your attorney will be Ms. Wills. Any priors, Ms. Roberts?
Yes, 8 cycles, 7 out of Georgia, 1 out of Florida. I saw 1 conviction for theft by shoplifting in 2019 out of Georgia, and then a DUI arrest in 2019 out of Florida, which had no disposition listed. And nothing further.
All right. Do you have his driving history by any chance?
If you give me 2 minutes, I can run it.
Okay. While we're waiting, Ms. Falk, are you familiar with his driving history? I'm sorry.
I am, Your Honor. Yes.
Go ahead.
His driving history is fairly extensive. He has a NOLO in 2022 for failure to obey stop sign and improper lane change that resulted in an accident in 2021, where his bond was forfeited, a license cancellation in 2019, speeding in 2019, 61 and a 45, an FTA in 2019, and speeding in 89 and a 55 in 2018, which he was declared a super speeder. I just went back 5 years because I felt that kind of encapsulated what kind of driver's history we were dealing with going into this case. In this case, as Your Honor has already stated, the defendant gave the name of Jay Hobson, as well as a ID from Nevada that was in the name of Tyrese Obas. He also initially gave Miss Parlier who is the person who he struck, a false phone number, but when she was unable to connect on that phone number, he gave her the real phone number. That's what the officers used then to locate the defendant and get his name. They then showed Miss Parlier the picture of the defendant, and she was able to identify him. The officer also said in the warrant that the defendant had multiple motor vehicle infractions, as well as a hit and run out of Alpharetta. So for those reasons, the state is recommending a $2,000 surety bond for this hit and run, no driving, and no alcohol, drugs, and weapons. The state's concern, and the reason we're asking for a surety bond, is because we are concerned about the failure to appear, given how the lengths this defendant allegedly went through to avoid being identified.
Ms. Kim, oh, sorry, Ms. Wills?
Thank you, Your Honor. Mr. Hicks is 29 years old. He is from Georgia. He reports that he is employed by me ×2 as a home health care worker. And he has been with that company since 2011. He does deny the allegations as alleged, and purports that he did provide his contact information to the alleged victim in this case. I would ask for a signature on bond. If Your Honor is not so inclined, I would ask for a $750 surety bond. And if Your Honor is going to limit his driving, or in regards to the driving, we would ask that he be allowed to drive if he has a valid license. But if Your Honor is going to limit it in any way, I would ask that he be allowed to drive to his place of employment and any medical appointments, and to also see his attorney.
Bond is going to be set at $1,500. It is a surety bond. No further contact with Maria Parlier. I'm not going to restrict his driving privileges. If his driving license is still valid, then he can drive, but he can only drive if his current driver's license is valid, he's got adequate insurance and proper registration for the vehicle that he's operating. Next court date is going to be May 16. Thank you.
I'm sorry, Judge Law, what was the bond amount?
$1,500 surety.
Thank you. Position 3, Cook.
It should- This is State versus Brandon Cook, case number 23 CR 002678Y. Mr. Cook has been accused of battery, domestic violence from a July 22nd, 2022 incident. Mr. Cook, you've been advised of your right to remain silent, and your attorney is going to be Ms. Wills. Any priors, Mr. Roberts?
I'm showing 7 priors, disorderly conduct conviction 2010, another disorderly conduct conviction from 2010, a reckless conduct conviction from 2017, and then an FTA in 2010, and nothing further to add.
Okay. Ms.
Your Honor, we also pulled a battery conviction from 2020 that involved a different victim. That was in our case manager system under, and I can pull up that case number. Additionally, the disorderly conduct, one of the disorderly conducts was actually pled down from a aggravated assault. The simple battery that the defendant pled to, excuse me, it was simple battery, not battery, it was 20 CR 001356D.
I'm sorry, 20 CR 00156D.
1356D.
Okay.
So he does have prior violent offenses on his history, Your Honor. We have had an opportunity to speak with the victim in this case, Ms. Dana Smith. She stated that they are in a relationship, they do live together, and they do not share any children. And although she stated they have been in contact and there's been no violence since then, and she does not fear him, our concerns in this regard are that this incident, which did happen last year, involved her coming home with her child. The defendant did not believe she had been at the hospital with her child, and then struck her, leaving a visible laceration over her left eye, and then fled the location. That, coupled with the defendant's violent history, gives us some serious concerns about the likelihood of reoffense. For that reason, we are asking for a $3,000 surety bond, no further contact with Dana Smith, stay away from 863 Hubbard Street Southwest, no alcohol, drugs, or weapons, 1-day anger awareness, and we would like to sound for Miss Dana Smith.
Ms. Dana Smith, if you'd like to address the court, you would need to unmute and start your video.
Hello.
Hi there. Ms. Smith, would you like to make some comments?
That incident happened last year and we have moved on.
I need to place you under oath.
Okay.
Your other right hand.
Oh, sorry.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
So we do understand this incident occurred on July 22nd, 2023. And we do understand that, I mean, it's not 20%, 2022. And what would you like to tell us while under oath?
That we have since moved on from that incident. We were working together, compromising with each other, and we also have started a business together. So it would be kind of hard to run the business if we don't have any contact with each other.
What kind of business is this?
It's a security business.
What's that mean?
We are a security guard company, so we secure different locations.
Does that mean that Mr. Cook can carry a firearm?
Yes, ma'am, and unarmed.
But he's working with individuals with firearms.
Yes, ma'am.
Okay. Anything else?
No, ma'am.
All right, thank you. Ms. Wills?
Thank you, Judge. Mr. Cook is, sorry, I believe he's 30 years old. Yes, he is 30 years old. He is from Georgia. As it was stated, this incident did occur back in July of last year. I also had the opportunity to speak with Ms. Smith, who echoed the sentiments that she made to the court today. I would ask that there be no violent contact between Mr. Cook and Ms. Smith, as they have just recently begun this company. Although my client is self-employed with the security guard business, he estimates that right now, since he is just starting the company, that he will only be making approximately $1,000 per month. So he will be qualifying for our services moving forward. My client states that he did not intentionally cause any harm to the alleged victim in this case, and that they have remained in contact and there have not been any other incidents since last July. So I would also ask for a signature on bond, as my client's resources are very limited. Thank you.
All right. On the battery family violence, the bond is going to be set at $1,500. It is a surety bond. If he doesn't make bond, his next court date is going to be May 16th. If he does make bond, then we will send notice to his next address. I'm going to allow for no further violent contact with Dana Smith. He may return to the 863 Hubbard Street location if that's where he resides. He's not to consume any illegal drugs. He's not to consume any alcohol, and he's not allowed to handle or be in possession of any firearms. So if there are any firearms at the Hubbard Street location, they must be removed. He cannot be in a job or in any occupation that requires him to be around or with any firearms. That is something that he has to distance himself from, because right now he's got an open case for family violence, and he previously had just completed a probation for simple battery, which was in May of 2022. In addition, once he bonds out, he would need to attend and complete a domestic violence intervention program. And that must be started within 60 days of being released on bond. And that is a 24-week program that Mr. Cook, you would have to commence. And once you have completed the program, you will need to submit the certificate of completion to either your attorney, or you submit it directly to the Solicitor General's office with your case number. Completion of this domestic violence program is not a sentence with regards to the case. It is a bond condition for the situation that you're in. It has nothing to do with sentencing. It's only a bond condition. Do you understand?
Yes, ma'am.
Your next court date is May 16th. If you make bond, then you will get a new court date sent to your address. No further violent contact with Dana Smith means that you cannot have any physical or verbal altercation with Ms. Smith. If there are any such altercations and the police get involved, you will be back in jail with no bond. Thank you.
Position 4, Fortune.
Thank you. I'm sorry, did you say Hutchins?
No, position 4, Fortune.
Fortune, excuse me. This is State versus Bachelor Fortune, 23 CR 002677G. Mr. Fortune's accused of criminal trespass from April 29, 2023. Mr. Fortune, you've been advised of your right to remain silent, and your attorney is going to be Ms. Wills. Any priors, Ms. Roberts?
Yes, I am showing a total of 19 cycles, 2 out of Florida, 17 out of Georgia. I showed at least 6 probation violations, a 2022 conviction out of Florida for grand theft, a 2008 conviction out of Georgia for theft by receiving stolen property, financial transaction card theft, theft by taking, and criminal trespass, 2006 criminal trespass, 2006 theft by deception, 2007 2 counts of theft by deception conviction, 2005 theft by deception and theft by receiving stolen property
Well,
conviction.
that's good. Thank you. Thank you.
Okay.
Ms. Polk?
Yes, Your Honor. We did have an opportunity to speak with Miss Beverly Glaze, who is the victim in this case. She stated that she and the defendant were in a relationship. They do not live together. So she resides at 492 Lake Drive in Hateville, and the defendant does not reside there. And this is her residence. She stated that they were at the residence when they got into an altercation. The defendant took her phone. She went to her neighbor's house to call the police. She stated this defendant has been violent with her in the past. And when asked, she stated that the defendant would call the police, but this is the first time she has called the police, and that she is in fear of this defendant, does not want contact and wants him to stay away from the residence. I would advise that staying away from the residence is a necessary component of this bond, being that the police had recorded that they had been out there 8 times from January 1st, 2023 to April 29th, 2023, which shows there's some kind of persistent issue that is happening here between the two of these individuals. Given that, and the fact the defendant was just recently convicted of a case out of Florida in 2022, we do also have concerns about the defendant's likelihood of reoffense and reappearing for court, being that we are not sure if he is a stable resident here in Georgia. For that reason, the state is asking for a $2,500 surety bond. Stay away from 492 Lake Drive in Hateville, Georgia. No further contact with Beverly Glaze, and no alcohol, drugs, or weapons. We would like to sound for Miss Glaze at this time.
Right. Miss Beverly Blaze, BL, I think it's AZE.
Yes, that is correct.
Okay. Ms. Blaze? All right, Ms. Wills, what's the defense position?
Thank you, Your Honor. My client is 41 years old. He has lived in Georgia since he was 4. He is single. He does not have any children. He is self-employed, where he buys properties and renovates them. He will not be qualifying for our services. As it was stated, he was in a relationship with Ms. Glaze. He was the one who called law enforcement on those prior occasions, which goes against him calling the police if he was battering Ms. Glaze. He denies any sort of physical contact or abuse between himself and Ms. Glaze, and that actually he was calling in regards to Ms. Glaze's son, who have been lurking around the property and premises. I would ask that Your Honor give him a signature bond. He has community ties here. And if your honor is not so inclined, I would ask for a $750 surety bond. And we would have no objection to no further contact if that's Ms. Glaze's, if those are Ms. Glaze's wishes.
And Your Honor, we do have, oh, sorry, I didn't mean to interrupt. We
That's
do
okay.
have Glaze, G as in girl and not B as in boy.
Oh, okay, so it's glaze. Okay. All right. $2,000 surety bond. Next court date's May 16. No further contact with Beverly Glaze. And to stay 200 yards away from 492 Lake Drive in Hapeville, Georgia. There will not be a one-time visit with an officer. He's absolutely to stay 200 yards away from Miss Glaze and her home or wherever she happens to be standing. Do not communicate with her in person, through a third party, through a phone, a computer, or even on social media. Thank you. Oh, no alcohol and no illegal drugs and no weapons.
Yes, ma'am.
Position 5, McCoy.
Henry Tobias McCoy is accused of simple battery domestic violence from December 15th, 2022. Mr. McCoy, you've been advised of your right to remain silent, and your attorney is Ms. Wills. The accusation that's been drafted against you is 23 CR 002-676A. Any priors, Mr. Roberts?
I am showing 3 prior arrests. I am also showing an open case, 21 CP 201-817. That is for battery, theft by taking, and aggravated assault. That arrest was from July 30th, 2021. And then prior to that was a 2009, sorry, marijuana misdemeanor that was amended to a non-fingerprintable offense. It was a NOLO plea and nothing further.
Thank you. Ms. Falk?
Yes, Your Honor, I will state that as to that 2021 CP case, the defendant is out on a $40,000 split bond. The victim is different than our victim in this case. Our victim in this case is Miss Takia Stinchcomb. We did have an opportunity to speak with her. She stated that they are in a relationship, they do live together, and they don't share any children. She does deny that he hit her, although at the time she said she was trying to stay away from him due to some previous arguments that she had been having with him, and she was trying to scoot past him when he pushed her away and grabbed her jacket and began tossing her around. She does state she is not in fear. However, based on the fact that the defendant is already out on bond for an aggravated assault, strangulation, and a battery case, we do have some serious concerns here about a risk of reoffense and the likelihood of harm to her. So for those reasons, we would ask for a $3,000 surety bond, no further contact with Ms. Stinchcomb, stay away from 2128 Larkwood Road Southwest, no alcohol, drugs, or weapons. We would also like to sound for Ms. Stinchcomb as she is here on the line.
Ms. Takia Stinchcomb, if you are present.
Hello, I'm here.
Oh, there you are. Okay, so the 2 dance witnesses. I was wondering who was going to appear for that. Okay. All right, Ms. Stinchcomb, if you'd like to contribute to this hearing, I need to place you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Ms. Stinchcomb, as you've just heard the prosecutor indicate, this is a charge that's been brought against him with regards to the alleged violence against you, and he also has an open felony violent case against him. The state is asking that I keep him away from you and from where you live. Do you agree with that?
I do not agree.
All right. What would you like to tell me?
Well, first, I would like to correct the prosecutor. Me and him, we do not live together, but we spend time with each other every day. We are in an active relationship. When I stated that I was trying to get away from him, that was not. We were in a conversation, pretty much a disagreement, and it was more so on my end, me being disrespectful towards him. No, he did not force himself upon me or anything. He was just pretty much trying to solve a situation in that moment that I was trying to run away from. As far as him swinging me around, it really wasn't a fight. He did not physically hit me or anything. And I actually called the police. It was more so me having concerns about me leaving the house, because he asked me to leave. You know, I wanted to be peaceful. And it was more so me calling the police to get a better understanding of my position as far as being a resident in the home. Since then, me and him have been, you know, partaking in counseling sessions. He has his own counselor as well. We have done couples. Since then, we have been on a family vacation. He has a son that's about to graduate this upcoming weekend from Georgia Tech. Like, he's a great man. I do not know of the previous incident, and I think that that was a false accusation as well. But as far as this case, no, he is not of any danger to me.
Okay.
Or my children whatsoever.
Your Honor, I do have a follow-up question.
Go ahead.
Ms. Stinchcomb, just really quickly, you stated earlier that you did not live with the defendant. Is that correct?
Yes, I said that once the lady called. I said that we were living together then, but I ended up leaving the home. But like literally, I want to say within the next 2 weeks, like me and him were literally back together. We decided to still move forward in our relationship separately until we come back together. But that is the goal, to come back together.
But at the time, oh, sorry, I didn't mean to interrupt. But at the time of this incident, you were living together.
Yes, ma'am.
Okay, I just wanted to clarify. And also, you said you didn't know about the previous incident. Is that correct?
No, I did not say that. I said I think that the previous incident was a false accusation. That's what I said.
Okay, so you were aware of the previous incident.
We were together, but it was like you would have to speak to him more so on that situation, because like you said, I'm not the victim in that, and it could actually be someone speaking against a being, because prior to then, like, this man is 45.
Whoa, stop. Unless you have the allegations in front of you, I'm not going to let you speculate about that case. All right?
And Your Honor, that was the state's point, that she is saying she's not a witness or a victim in that case, but yet she's sitting here saying it was a false allegation with no additional information. So I just wanted to make that point. That's all for the state.
Thank you. On the simple battery domestic violence bond is going to be set at $5,000. It's going to be a signature bond through pretrial services. While Mr. McCoy is out on a signature bond, he will make sure that we have his correct mailing address within 30 days of being released. He's to have no further violent contact with Takia Stinchcomb. He's to stay away from 2125 Lachlan Place, I believe.
Ma'am, sorry to interrupt, Your Honor. That is his home. That is his home.
So you have a different address?
Yes, ma'am.
Okay. Do you concur with that, Ms. Polk?
Your Honor, I would ask Ms. Stinchcomb if she could direct her current address to myself or Ms. Cheney in the chat, because we do not have it at this time.
Okay. Ms. Stinchcomb, for purposes of monitoring this case, you would need to reach out to the Victim Advocate's Office and make sure that they have your current address, just so that we can make sure that because my order is going to say that he can stay away. He needs to stay away from 2125. I think it's Lotchwood Place. I can't read my writing. That's the problem.
It's
Lotchwood
2128.
Yeah. But he may return to that location as long as it's confirmed that the victim does not live there. All right. So it would be very helpful if you provide your correct mailing address to Victim Advocate, so that we can make sure that you have a separate mailing address. No illegal drugs, no alcohol, no weapons, and no firearms. Mr. McCoy, if you possess any weapons or firearms, you have to surrender them to the authorities for destruction. While you are out on a signature bond, you will attend and complete a domestic violence program, and you must begin that program within 60 days of being released. You will report to pretrial once a month. You'll be subject to random screens for alcohol and or illegal drugs. No further violent contact with Ms. Tinchcombe means there cannot be any physical or verbal altercations with her. And if there are, authorities can get involved, at which point then your signature bond will be revoked and you'll be in a no bond status until you have a court date. Thank you.
Position 8, sellers. Judge Law, for position 5, it was 5,000 SOB for pretrial, correct?
That's correct. And I guess I need to do it per judge. Oh, why am I putting two glasses on my face?
And Your Honor, we also had, did you say complete
DBIP,
in
yes,
30
with-
days or
within-
60?
Within 60 days of being released.
Thank you. And we did have her updated address. I have communicated that to Ms. Grace.
I thought I saw something on the chat. Okay, yeah, she sent it to everyone, so. All right, this is position number 8, Samuel Sellers, charged with battery domestic violence from an April 30th, 2023 incident, case number 23 CR 00268J. Mr. Sellers, you've been advised of your right to remain silent, and your attorney is Ms. Kim. Ms. Roberts, any priors with regards to Samuel Sellers?
No priors, first arrest.
All right, thank you. Mr. Young or Ms. Falk or Ms. Duncan? Who's for the,
Your Honor, maybe I am incorrect, but I believe this is Ms. Duncan's case. If it's Mr. Sellers.
I'm sorry, I have it, Your Honor. My internet went out.
Oh.
briefly.
oh no, that's okay, you're back, thank you.
Okay, we're on sellers, is that correct?
Yes,
Okay, in this case, the state is going to be requesting a $3,500 surety on the count of battery family violence. The victim in this case is Jaden Story. That's Jaiden Story, common spelling. She indicated to officers once they arrived at the location of 309 Mount Zion Road, number 3, which was an Airbnb, that her and the defendant are from Arkansas. However, they are living boyfriend and girlfriend. They had come to Atlanta for entertainment, and they were at the stadium, and she told officers that he left her at the stadium. She took an Uber back to the B&B, and when she got back to the B&B, she indicated that the defendant was intoxicated and he had become belligerent with her. And he started to attack her and send her text messages while she was on her way there, stating that he hoped she got raped. And then when she got home, he grabbed her by her arms and squeezed her, leaving noticeable bruises on her left arm, and officers believe those to be consistent with being grabbed. And then she also indicated to officers that he struck her in the face with his hand, causing visible redness that was observed by officers on her left cheek. Officers further indicated, and Ms. Story further indicated to officers that he began to trash the B&B. Officers notated damage around the B&B, and they indicated that they believe this defendant to be intoxicated because he had a strong odor of alcoholic beverage coming from his person. His speech was slurred and he had glassy, bloodshot eyes. It is for these reasons that the state does have the concerns about the risk of reoffense, as these parties are in a relationship and they live together. In Arkansas, we do also have concerns about ties to the community because admittedly they do not live in the state of Georgia. For those reasons, we're requesting a $3,500 surety. No further contact with Jaden Story, as this did just happen yesterday. We do not believe that there's been an adequate cooling off period, and for the safety of that victim, we believe that's more than reasonable. We'd ask for a stay away from wherever they reside. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. We were not able to make contact with Ms. Story, although we attempted to. However, we would like the court to sound for her when appropriate in case she is here.
Miss Jaden Story? Jaden Story? All right. Ms. Kim?
Yes, Your Honor. Mr. Sellers is 22 years young, and he has been here in Georgia only for this weekend, Your Honor.
Oh, yes, I know, the busy weekend that we just had, yeah.
And My client, this is his first offense. He's gainfully employed at Natural Energy Solutions in Arkansas, and he really got to drive back so that way he can go to work tomorrow. He does not want to lose his job. He graduated from high school successfully, and we do have his Arkansas address. Your Honor, we would like to request for signature on bond. Thank you.
This Mount Zion location, is that the hotel or where his personal items are? I don't know.
That is the Airbnb that they were.
Oh, the Airbnb, that's right, okay. Right. Bond is going to be set at 2,500. It is a surety bond. Unfortunately, it doesn't qualify for a signature bond due to lack of community ties. This is an out-of-state resident. And so I'm not going to be making any reporting requirements. Yes, Mr. Sellers.
I have some family. Oh, sorry. I have some family in Vidalia. I was going to request if they could sign a signature bond.
No,
Thank you.
they live in Vidalia. The fact that you have relatives here is not sufficient to establish the community ties that we require. It's a $2,500 surety bond. Now, the rest of it's up to you. No further contact with Jaden Story, no alcohol, no drugs, no weapons. Once you make bond, your next court date will be sent to you at your current mailing address. So whatever we have on file right now, that's where we're going to send all your notices. If you do not make bond by May 16th, then we will see you in court. But right now we have a Grouse Road address. Is that your correct address?
No, ma'am.
All right. You would need to provide once you are released on bond, you need to come down to this courthouse and update your address in writing as to what your current address is. That's it. Thank you.
Thank you, Judge.
Position 11, Smith.
Sorry. State versus Christopher Jamal Smith, accused of battery, domestic violence, and simple battery, domestic violence. From February 15, 2023, the accusation number is 23 CR 002-685J. Mr. Smith, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kim. Any priors, Ms. Roberts?
Give me one moment, please, Judge.
Oh, Miss Wills. Is it Miss Wills? Oh, Miss Roberts. Sorry. Gibson.
Judge, I don't have his GCRC. Does the state have it by any chance? I don't have it in
Let's
the
see.
system.
Miss Duncan or Miss Fulk?
I have that he has 2 arrests. The other one was not a conviction. I can pull up Odyssey if the court would indulge me a moment to get what that arrest was. However, my computer is acting a little silly, so if Ms. Falk is available and could tell the court what that second arrest is, that
Miss, hang on, Francois, can we address somebody else while we run Mr. Christopher Smith's GCIC?
Position 12, Thomas.
This is State versus Jonathan Thomas, accused of criminal trespass from April 30th, 2023. Mr. Thomas, you've been advised of your right to remain silent, and your attorney will be Ms. Kim. Your accusation number for this particular matter is 23 CR 002-686C. Ms. Roberts, do we have a GCIC and Mr. Thomas?
I am showing 8 cycles, 1 out of Georgia, 7 out of Florida. 2022 trespassing conviction out of Florida, 2022 petty theft conviction out of Florida, and then a 2020 trespassing conviction out of Florida. Yeah, nothing further.
Thank you. Ms. Duncan?
Yes, Your Honor, in this case, I did see those 8 cycles. I did see an additional resisting arrest without violence for this defendant. Most of his history is out of Florida. He has one in Georgia. This incident occurred at the Interlock, Atlanta, which is located at 1115 Howe Mill Road. It's indicated that persons in charge of that facility, the rightful owner or the authorized representatives of that location, indicated to the security that were there at the time, which was a Walden security guard, Mr. Montague Taylor, that the defendant in this case had returned to the property after being told on multiple encounters in the past not to return. The security guards entered the stairwell along with officers, and at that time, they were able to take this defendant into custody. This current case is currently on a $30,000 surety bond. We do have some concerns about the risk of reoffense in this case, given that this defendant does have recent convictions for trespass out of Florida that were guilty adjudications. We also have some concerns about his ties to the community, again, given most of his cases are out of Florida, with the most recent being last year in 2022. It's for those reasons that the state is willing to reduce that $30K surety to a $2,000 total surety bond with the stay away from the Interlock ATL at the address previously stated on the record, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Great, Ms. Kim?
Yes, Your Honor, Mr. Thomas is 23 years old and he was born in Florida, but he came to Georgia about 2 weeks ago to find a job. And he has been actually residentially challenged for the last 2 weeks. And also he does not have a phone right now. Due to the past incarceration, he is out of job and he's searching eagerly to find a job. He is qualified for public defender's services since he's financially challenged right now. He gets disability check, but it's not much, Your Honor. And he claims that he has no addiction to drugs or alcohol, and he completed up to 11th grade. He is eager to have a new opportunity here in Georgia. Thanks.
Yes, it'll be very interesting to find a single building in downtown Atlanta that doesn't have the odor of weed or marijuana. So I'm sure that's a very rare sighting. But nevertheless, in Georgia, unfortunately or fortunately for whoever concerned, marijuana is still not legal as a recreational activity. Bond is set at $1,000. It's a surety bond to stay 200 yards away from the Interlock facility at 1115 Howell Mill Road in Atlanta, Georgia. No illegal drugs, no alcohol, no weapons. And next court date is May 16. Thank you.
I was gonna see if I could ask Ms. Kim.
Yes, I'll be happy to call you and answer all those questions.
Well, yeah, I was interested in the
Keep your mask up for me.
I was interested in pre-trial service.
You don't qualify.
All right. And how can I get my bond paid?
I'll explain it to you. Position 13, Williams.
Elijah Williams is accused of battery domestic violence from April 30th, 2023. Mr. Williams, your case number is 23 CR 002-687E. Mr. Williams, you've been advised of your right to remain silent, and your attorney is Ms. Kim. Ms. Roberts, any priors?
I'm showing this as the first arrest.
Ms. Duncan, I do see a party of interest, Michael Williams on the Zoom. Would you like to proceed first, Ms. Duncan?
Yes, Your Honor, I would.
Go ahead.
In this case, it did occur on yesterday at 516 Boulevard Northeast. The victim in this case is Namia. I'm sorry. I'm going to use the initials. She's 16 NW, who is the sister of the defendant in this case, and apparently they both live at this location. There was an altercation between the victim and her father, and it's indicated that the defendant in this case got in between the two of these parties while they were in a verbal altercation.
Yeah,
in
I'm just gonna pause you for a minute. Mr. Michael Williams, could you mute your screen? There's a lot of background noise.
Oh. Sorry.
Thank you. Sorry about that, Ms. Duncan. You were saying that,
There was a verbal altercation between her and her father, Mr. Michael Williams, and the defendant got involved and began to push the victim into her room. During that altercation, it said that he made contact with her face by striking her and leaving a visible laceration that was bleeding that officers had saw. When they arrived on scene, they indicated that the victim was stating that she was not going to spare him this time. When asked about how she received the laceration, they talked to the father at the time. He indicated that he was in an argument with his daughter and that he was trying to get her to go into her room, and the brother did not want them to be arguing, so he jumped in and he grabbed her, and the brother grabbed her and started to swing. However, he did not hit her. The father indicated that he doesn't know how she got the laceration on her face. He believed that it may have been caused by him causing her to fall during the altercation. Officers separately also spoke with the defendant. He indicated to officers that he did, in fact, strike the victim in this case, but he denied striking her in her face. Given the testimonies given to the officers and the visible injuries as alleged and witnessed by the officers, this defendant was taken into custody. We were able to talk to the victim's father in this instance earlier today. He indicated that he has a medical condition that he was teaching his children about, and that when he began to argue with the victim in this case, the brother jumped in. He indicated that his daughter does have anger issues and that he doesn't necessarily know how she got the laceration on her face, and that he wants the defendant to return home. However, Your Honor, the state does have some concerns about the risk of offense. These parties are siblings and they do live together. And this was an altercation that was not involving the defendant, and he took it upon himself to jump into this altercation. And we do not believe necessarily that there has been an adequate cooling off period, as this did just occur yesterday. We also have some concerns about the particular danger to this individual victim and possible intimidation, given the statements that she made to officers when they first arrived. It's for those reasons, Your Honor, that we're going to be requesting a $3,500 signature bond, no further violent contact with the victim, whose initials are NW, no alcohol, no alcohol, drugs, and weapons, 1-day anger awareness, and no further violations of Georgia law.
any objection, Ms. Kim?
As long as they have no further violent contact, we
Yeah.
have no objection.
I believe that was the requirement, no further violent contact.
Yes.
Yes.
All right.
And I do believe Mr. Williams wants to speak.
In a moment. So I do notice the NW is on the Zoom. The father is on the Zoom, and of course, Elijah Williams is on the Zoom. And I've read this warrant. Everybody seems to have a different version of what happens, as was reported to the police officer. So at the present time, there is no way for me as a judicial officer to decide which version is correct. Who hit who was struck in the face, who fell on someone. It doesn't matter what you say, Mr. Williams. All I'm trying to tell you is that you have one version, your daughter has another version, your son has another version. All right? Now I'm going to set a bond. And if Elijah doesn't comply with the bond, that's on him. That is all on him. It doesn't matter what you say, it doesn't matter what NW says. But if he violates the condition of the bond, he's going to be back in jail in a no bond status. Y'all made this my business when it became violent. Siblings argue. No, Mr. Williams, you can put your hand out. You're not saying anything. Y'all made this my business when this crossed the line and became physical. If you're not happy with your sister, if you're not happy with your brother, you walk away, you don't push and shove. But once it happens, you make it my problem. Bond is set at 3,500, signature bond through pre-trial. You can sign up for your bond. You don't have to pay your bond today, but you have to comply with these conditions. No further violent contact with your younger sister, NW. No further violent contact with Michael Williams. And you have to report to pre-trial once a month. If you don't report, if you get arrested again, or if you violate any of these conditions, you get a very good e-bike to come back to jail and spend the rest of the time with us. Do you understand?
Yes, ma'am.
No alcohol, no illegal drugs, no weapons, and no firearms. So if there are any firearms at the home, they must be sent away or sent to the police for destruction.
All right.
If you cannot live under the same roof with your sister, then you need to find alternative housing. Because I don't want you to come back to jail. But if you can't get along if you cannot argue and it cannot get, without it getting physical, then you need to find somewhere else. All right? I'm not letting any of you talk right now because you are the one in jail, Elijah, at this young age because of a family squabble. So shame on you, shame on the family. I don't care, but if you don't stick to these conditions, you are writing your invite back to jail. Next court date will be sent to your address. Make sure that you come back. Yes, Mr. Williams, Mr. Michael Williams, what would you like to tell me?
Yes, I just wanted to say a few words one thing about the bond, and I did have a question. I was the only witness to what happened.
No. There are 3 witnesses. You.
No. What I mean
No,
is
there's you, there's
seizure.
Naima, and there's Elijah.
Right. I thought that I was having a seizure because I started having seizures.
Mr. Williams, I've already told you, I've read the warrant. I know there are 3 different positions. Right now, Elijah has an obligation to stick to the bond. Okay? If you're not happy with him staying in the house, you can tell him to go somewhere else. That's your home.
Well, he was actually being a peacemaker. That's why I wanted to just get that straight for the record. What happened was
Please, Mr. Williams, please do not mention any facts, please, about the case, so we can protect
Can I just speak about the bond?
Within 24 hours, you can pick him up. Yeah.
And Your Honor, the state,
the
I'm
bond
sorry.
would be 3. They say the bond would be how much again?
You don't have to worry about money at this point, Mr. Williams.
Oh,
Please
okay. Okay.
All right.
I was just asking because due to my seizures, I haven't been working. I had to scale back my work hours due to seizures and stuff. So I was a little worried about the amount of the bond.
Don't worry about it, please.
Okay.
All right, thank you.
And Your Honor, just briefly, the state would like to make it known for the record that the victim in this case is on the line.
I can't hear you. Mr. Williams, please mute your screen. I'm sorry, Ms. Duncan, you want to make it clear for the record that what?
That the victim is on the line and we would like to sound for her as well as she has
she's a minor.
But she does have a right to speak in accordance with.
She's a minor.
It's fine. Per the record, we just would like to make it known that we would like to sound for her in accordance with Marcy's law.
I know she's here. She's got her name on the screen. Okay, thank you. Next case, Francois.
Position 11, Smith.
Hey, come on, man.
For the violent content with Michael Williams and NW. Yeah, thank you. We are back to, have we got the GCIC now, Ms. Duncan?
Yes.
I got it.
Right, so this is Christopher Smith, position 11. What is GCIC?
I show no priors.
Okay. And Ms. Duncan, what's the recommendation?
Same, Your Honor. This case occurred on February 15th, 2023 at 1033 Hollywood Road, Northeast, apartment T8. The victim in this case is Terry Smith. Terri, who is the mother of the defendant. In this case, it's indicated that he arrived to her location which he does not presently live at, because his brother let him in, and there was a verbal altercation where he began to call her out of her name, and she asked him to leave the location. He refused. The verbal altercation turned physical when he turned around and punched her in the face, leaving a visible red mark that the officers were able to view. She also further indicated that it was tender to the touch. She left the location. About 3 hours later, she came back to that location. The defendant was still there, and the altercation continued to the point that this defendant did grab her. Well, when she tried to walk away from him, he came up behind her and picked her up and slammed her to the ground. She stated that after being slammed to the ground, she left again and went to her godmother's house, who was across from her apartment building. She indicated at that time that she did want to go forward with charges against the defendant in this case. We do have some concerns about the risk of reoffense, given that there is a 3-hour time difference between these attacks, one of which caused visible injury that officers were able to view. We do have some concern about the intimidation factor and the particular danger to this individual victim, given the statements that were made and the actions that were taken against her for asserting her right to have him leave her property. We were not able to make contact with her. However, we would like to sound for her when it's appropriate. It's for these reasons that the state is going to be requesting a $6,500 total surety. That's $3,500 on the battery family violence and $3,000 on the simple battery family violence. No further contact with Terri Smith. Stay away from the incident location, which is her home that she indicated to officers he does not live at. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. And we would like to sound for her just in case she is here.
Okay. Miss Terri Smith. Okay. Ms. Kim?
Yes, Your Honor. Mr. Smith is 31 years old. He was born and raised here in Georgia. Your Honor, he has no objection to stay away from that 1033 Hollywood Road, and also no further contact with his own mother, who was actually high from her drug use, per my client. My client has been going through a lot of challenges. He was stabbed by Jonathan Tidwell not that long ago. So he could not get any employment because of his injury. And ever since January 2023, he has been unemployed and he does not have a place to stay. And yet he will be able to stay with his uncle, who I was able to speak with, and yet I don't see him on the screen either. But anyway, he successfully graduated from high school, and we would like to request for maximum $1,000 good bond for each charge. Thank you.
You're asking for a maximum of $2,000 total?
Yes, of course, we strongly prefer signature on bond. This is his first offense ever.
All right. On the battery domestic violence, that's going to be a $1,500 surety bond. On the simple battery domestic violence, that's going to be a $2,500 signature bond through pretrial services. The total bond is going to be a $4,000 split bond. Out of this $4,000 bond, Mr. Smith, you're going to pay a portion of it, which is $1,500, and the rest of it is going to be through pretrial services. You will report to pretrial once a week, once a month. You will have no further contact with Terri Smith, and you'll stay away from 1030 Hollywood Road. Now, that's the address that's provided in the warrant, but Mr. Smith, Christopher Smith, has a 1033 Hollywood Road address.
Yes.
Do they live in the same complex?
They used,
On the same location?
they used to live together, but he will find another place.
All right.
And it was indicated to the state and per the documentation that he did not live there.
All right. So, Mr. Smith, yes, sir.
I just wanted to say one thing for the record.
I
Right.
just want to know whether you live at the Hollywood Road, Hollywood.
Yes,
Road.
yes, ma'am. At the moment I do, but
Okay.
I guess when I get out of here, I won't be staying there.
You are absolutely correct. You are to stay away from the entire complex at 1030 Hollywood Road, the entire complex. You may return one time only with a police officer to go and retrieve your belongings. And if there's any breach of peace, you're to immediately stop and leave the premises and not return anymore until further order of the court. That visit cannot exceed 60 minutes.
Yes, ma'am.
And within 30 days of being released, you must update the court with your new address, your phone number and email. Yes, sir. Now, do you have a question? What other questions do you have about your bond?
I just want to state something for the record. It says right here in paragraph 4 on the incident report that when the police came and they assisted.
Mr. Smith, I strongly recommend you to stay silent. This is not a trial. This is only for bond. You have a right to remain silent. We don't want to hurt your case.
I just don't want the judge to see me as a violent individual when it says in the report that when the police came to assist the situation, they didn't see any physical marks or anything that took place on this actual day.
Okay, so noted.
And I didn't hurt her, period. I'm the victim here. I got slashed in the face and bashed in the head. I'm here for no reason, and I don't have any money to get out of jail. I'm broke and hurt. I've been stabbed up. I got a victim advocate named Miss Marilyn Morgan
Mr. Smith?
from the district attorney's office.
Mr. Smith, I wish I could take into account your version of the events, but right now I have the police officer's sworn testimony and I have your version. So you need to work with your attorney. I'll see you on May 16th, and hopefully more information will come to light at that time.
Yes,
And
ma'am.
your attorney can ask for a modification of the bond if you're not unable to afford this one. But this is the lowest I can go right now, based on the allegations set forth in the warrant and considering the situation. Thank you.
No problem.
Judge Law, for the split bond is 2,000 good bond, and then the second simple battery is 2,000 signature bond through pretrial, or is it through the jail?
On the battery, family violence is 1,500 good bond. On the simple battery, it's 2,500 signature bond through pretrial. No contact with Terry Smith, to stay away from the entire complex, one-time visit with police officer, and must update us with his new address within 30 days.
Okay, so 1,500. Okay, thank you, Judge Law.
Thank you. Okay, I
And
think
then you know
that,
what, Judge Law, for we do have a waiver of appearance. That's gonna be,
Nettle?
yes,
Yeah.
Mr. Nettle.
Okay.
Actually, not waiver of
Not
appearance,
waiver
it's a
of
medical
appearance.
reset.
Oh, it's a radical reset. Okay.
Yeah.
That was my understanding, Your Honor.
All right,
Yes,
so
that was my
Mr.
request.
Nettle is going to be addressed tomorrow at 2 o'clock on May 2nd. Just to go over the calendar, Blackwell, position 1 is a 3,000 signature bond, further notice. 2, Bonaire is a 5,000 signature. Thank you, Francois. I'll see you later.
All right,
2, Bonaire is a 5,000 signature bond through pretrial, further notice. 3, Cook is 1,500 surety, May 16. 4, Fortune is a $2,000 surety bond, further notice, May 16. 5, McCoy is a $5,000 signature bond through pretrial. 6, Nettles a reset till tomorrow, see calendar. 7, Pulliam is a 2,500 surety bond, reset May 16. 8, Sellers is a 2,500 surety bond, reset May 16. 9, Shackelford's a 3,000 split bond, reset May 16. 10, Simmons is a 1,750 surety bond, reset May 16. 11, Smith is a 4,000 split bond, reset May 16. 12, Thomas Jonathan's a $1,000 surety bond, May 16. And 13, Williams is a 3,500 signature bond with pretrial, further notice.
We also had the add-on, Your Honor.
Oh, the add-on, yes, sorry, it's a 1,500 surety bond, further notice to May 16.
Thank you, Your Honor.
All right, folks, y'all have a good afternoon. And I'll see you one of these days. Take care. Bye-bye.